raises the question whether our nation's most powerful legislative body, the United States Congress, is legitimate. To many, I fear that raising this sort of foundational question will seem either odd, pointless, or perhaps both. Or instead, maybe something better left to a political philosophy seminar. In a way, though, that sort of reaction was a principal motivation for me in organizing this panel. In recent years, popular discourse has really increasingly taken up questions concerning the legitimacy or practical viability of many longstanding features of our constitutional order, including, but not limited to, features of our legislative process. Within the legal academy, though, there seems to be a comparative reluctance to take seriously proposals for wholesale reform. Now, I will say that in the year since we've been organizing this panel, the willingness of legal academics to take wholesale reform seriously has increased, at least in some areas. Most notably, academics and the public recently engaged in an intense debate concerning the legitimacy of the federal judiciary and the United States Supreme Court in particular. And to some extent, my hope is that that debate can serve as a sort of model for discussions concerning our legislative institutions. Now, let me close by emphasizing that by no means is it an assumption of this panel that Congress is illegitimate or that wholesale reform of our legislative institutions is required. Instead, the goal here is to start a serious conversation concerning what sorts of reforms are needed, if any. Rather than assuming a radical conclusion, in other words, the plea motivating this panel is that we not simply assume the opposite. Okay, and so with that, I want to turn things over to our wonderful set of panelists. Our first speaker today is Josh Chaffetz, professor of law at Georgetown University Law Center. After Professor Chaffetz, we'll hear from Blake Emerson, assistant professor of law at the University of California, Los Angeles School of Law. Next, we'll have Miriam Seifter, associate professor at the University of Wisconsin Law School. And finally, we'll hear from Fernita Tolson, vice dean for faculty and academic affairs and professor of law at the University of Southern California, Gould School of Law. Following our panelists' presentations, we will open discussion to audience questions. I ask that you use the chat function in the AALS web interface to raise your questions so that I can then relay them to our panelists. Okay, and with that, let me hand things over to Professor Chaffetz.
Thanks so much, Ryan. Thanks for inviting me to be here, and thanks to everyone for coming out, albeit virtually. Okay, so in some sense, what I want to do is flip Ryan's sort of organizing schema a little bit on its head, in the sense that I think what I'd like to talk about is something that is often thought of as being illegitimate, and I want to try to make a case for its legitimacy. So in particular, I'm interested in the intersection between congressional oversight and congressional legitimacy. Oversight is one of Congress's most important functions, and yet the way Congress exercises it perpetually, this is not just a recent phenomenon, this is a phenomenon you can trace back to the early 20th century rise of oversight. It continually raises questions that sort of strike at the heart of this legitimacy question. Prominent oversight hearings are often described dismissively, even by purportedly neutral analysts, as mere spectacle, political theater, reality TV, a circus, goat rodeo, in fact, is language I have seen used in purportedly serious publications. And indeed, even those defending particular exercises of congressional oversight often accept the same account of its legitimacy, either insisting that the particular investigation can't accurately be characterized that way, or else urging their sort of co-partisans not to allow it to descend to those depths or something like that. Of course, the Supreme Court has recently bought into this account as well, giving us the image of a Congress corrupted by performative attempts to exert an imperious control over the executive branch. That's quoting John Roberts, who in turn is quoting Alexander Hamilton, joined by the entire liberal wing of the court in Trump v. Mazars last term. In short, there seems to be a sort of cross-partisan, cross-ideological consensus, one that partakes, I might add, of the anti-theatrical prejudice that's been core to Western political thought since at least Plato, that showy, performative, or theatrical uses of oversight tools are illegitimate, and therefore, in turn, damage congressional legitimacy writ large. On this consensus view, what good congressional oversight really is first and foremost fact-finding. Right? So to the extent that any particular use of oversight tools is characterized more by something like perspective proclaiming, it's accordingly more theatrical or performative, and therefore less appropriate or legitimate. In turn, this means that oversight, when it's done right on the consensus view, is largely bipartisan and civil. That is, if the facts are all that we're after, the facts really care about your partisanship or your ideological affiliation. So you can find this consensus view, as I said, expressed by journalists, by scholars, by members themselves across the political spectrum. You can see it in purportedly nonpartisan places like the Congressional Research Service's Oversight Manual and things like that. And this consensus matters not only because it affects public perceptions of Congress, which in turn affect congressional power vis-a-vis other branches, but even more immediately, it affects the way the other branches directly interact with congressional institutions, as we saw in Mazars, in the DC Circuit's McGahn litigation, and in lots of other cases dealing with oversight, as well as in how the White House itself has treated oversight requests, most prominently in the Trump administration, but also in the Obama administration, also in the George W. Bush administration. So what I'd like to do here is actually make the case for the legitimacy of performative uses of oversight. That is, uses that, I'd like to suggest that such uses of oversight tools actually comport with a descriptively richer understanding of the relationship between interinstitutional politics on the one hand and public politics on the other than this consensus view does. And I should say, I'm sort of paraphrasing an argument that I've made more fully in an article published a couple months ago in the Fordham Law Review titled Congressional Overspeech. And that's sort of the name I've given to this phenomenon, right? The use of oversight tools for communicative purposes. So I've called it congressional overspeech. And I've argued that there are basically sort of three core indica of overspeech. And in sort of increasing order of controversiality, they are its communicativity, its performativity, and its divisiveness. So first, this question of communicativity, right? So proponents of the consensus view of oversight do in fact recognize a role for public communication and oversight, but they insist that communication has to remain secondary to fact-finding, right? So it's fine to tell the public what you've learned, but the point of oversight is the learning, not the telling. But there's another tradition well expressed by a young Johns Hopkins doctoral candidate named Woodrow Wilson, who wrote in 1885 that the informing function of Congress should be preferred even to its legislative function. When earnestly and purposely conducted, congressional speech clears the public mind and shapes the demands of public opinion. Now, it's worth noting that Wilson's argument here is for an argumentative use of oversight tools, right? Congress should speak in such a way as to shape public opinion. In making this argument, Wilson was acknowledging the interdependence of institutional politics and public politics in a way I think that the consensus view of oversight obscures. And we know that hearings can in fact have this kind of argumentative impact. So in the most detailed study ever done of the effects of oversight of the presidency, Doug Kreiner and Eric Schickler found that increasing the number of days of hearing investigating the executive branch in a month from 0 to 20 decreases presidential approval on average by about 2.5%. Those changes in presidential approval, of course, not only influence upcoming election results, they also affect the ways in which institutional actors behave in between elections. So consider, for example, the fact that Reagan's unpopularity was almost certainly a factor in the defeat of the Bork nomination to the Supreme Court. And the reason that Reagan was so unpopular at the time was that the Iran-Contra hearings had just wrapped up about a month before the Bork hearings began. So using oversight tools to communicate with the public can therefore be a significant tool in interinstitutional politics as well as political politics. Okay, the second sort of indica of overspeech is its performativity. Now this, of course, is highly suspect on the consensus view, so much so that theatrical is used as a pejorative with no further explanation needed. As I said, this sort of calls on an anti-theatrical prejudice going back millennia, but it also follows from the sort of basic logocentric premises of consensus view of oversight. Right? If the lodestar of oversight is finding facts, then it shouldn't matter how those facts are presented. And indeed, any attempt to appeal to either authority or emotion, that is either to ethos or pathos in the classical rhetorical argot, is deeply suspect. Let the facts speak for themselves is sort of the consensus view. Except, of course, that as decades of performance studies scholarship has made pellucid, facts don't speak for themselves, right? All social behavior is performative, and how that activity is performed affects how it will be received, even when what is being performed is authentic and truthful. So the veteran political journalist Jodi Kantor told the Yale sociologist Jeffrey Alexander about covering campaigns, it's theatrical even when it's incredibly authentic. She was describing Obama's campaign style in 2008 when she said that. Thinking explicitly in terms of theatricality can actually help us make sense of various choices that political actors make, and specifically that congressional actors make when making use of their oversight tools. So for example, casting matters, right? Sometimes this is about broader cultural cachet. So when Ben Affleck is called to testify about the situation in the Congo, it's not because he knows more about it than regional studies experts, but rather because his testimony will garner more attention. At other times, it's about a more specific authority, as when, say, a number of career Foreign Service officers were testified at Trump's impeachment hearings in a manner that was sort of calculated to impart gravitas. Scenery also matters, right? So congressional chambers and committee rooms designed to project gravitas. That makes an influence on the viewer, right? You have the American flag sprinkled liberally about, you have the seal of the United States on the dais behind the presiding officer, et cetera. Costuming matters as well. Think about the members from Western states who routinely wear cowboy boots into Congress, even if they don't wear them in their home district. Or think about Alexander Vindman testifying in his military uniform, even though he didn't wear it in his job at the National Security Council. Props can matter too. So think about when Attorney General Barr refused to testify before the House Judiciary Committee, and Representative Steve Cohen brought a bucket of cold fried chicken to the hearing to make the case that Barr was being a chicken. A sort of use of props that garnered significantly more attention than if he had just sort of made a speech calling out Barr's refusal to appear. And finally, there are choices around scripting, right? So this can involve the sort of logos heavy, just the facts material on which the consensus view focuses, but it can also involve a lot more, right? It can involve bringing forward witnesses with heartrending, or for that matter, uplifting stories designed to put a human face on policies, right? All of these are going beyond the facts and are using a certain kind of performativity in an attempt to make an argument that not only will be heard by the public, but will act upon the public in the way that Wilson posited that it could. The final sort of major indica of overspeech is its divisiveness. And this, I think, is the most controversial. And in contemporary politics, this generally means divisiveness along partisan lines, although it can also mean divisiveness along ideological lines that don't always track party. So on the consensus view, right, divisiveness is a sign of oversight gone awry, right? Just as it shouldn't matter whether a beat cop investing a homicide is a Republican or a Democrat, neither should it matter whether a member of Congress investigating accusations of executive branch malfeasances. But again, I think if we think in terms of overspeech, of public communication, of attempts to win over the public, and if we think especially in terms of fractured publics, right, the idea of winning over some subset of the public, divisiveness can actually start to seem like a sort of tool of public communication, right? Sometimes it is a goal to only move one subset of the public, or to get sort of your side all on the same page, right? Sometimes choirs need to be preached to, and that is sort of often an effective and important means of public communication. Okay, so why might someone think that overspeech, right, this sort of communicative, performative, potentially divisive use of oversight tools is a legitimate way for Congress to behave, right? As I've described it, the sort of consensus view holds that these are all indica of illegitimacy, and I'm suggesting precisely the opposite. And I think the answer goes to a thread that's been sort of running throughout the discussion so far. That is to say, precisely what I think makes these kinds of uses of these tools legitimate is that they connect public and institutional politics in a thick and rich way. That is to say, they tie the behavior of institutional actors into the public in a much thicker way than if we simply said, well, you know, elections can be fought every 2, 4, or 6 years, and you know, you can do your campaigning on the stump, but campaigning must be kept sort of hermetically sealed off from governing. Right? There's politics, there's policy. The two shouldn't meet, and oversight is the sort of tool of policy. Right? That's sort of underlying the consensus view, and I think that's a descriptively thin, but also normatively poor account of how we want our elected representatives to behave. Right? I don't think we want campaigning, or I think a sort of, and obviously the democratic theory underlying this is sort of too much to get into in this space, but I don't think we would want an account that suggests that those two things have to be that sort of hermetically sealed off. And I think that the communicative use of oversight tools, that is to say overspeech, is one of the central ways in which the legislature is able to sort of link the two together, and especially to link the two together in conflicts with the executive, with an executive that many people are sort of concerned is increasingly out of control. So that is sort of in a nutshell, right, my case for why this thing that is often described as an aspect of congressional illegitimacy is in fact a sort of deep source of congressional legitimacy. So I look forward to your questions, and I look forward to the other presentations as well.
Awesome. Thank you, Josh. Next, we'll have Blake Emerson.
Thanks. So, most of my research is on administrative law and the intersection between administrative law and democratic theory. So these are the question about Congress's legitimacy comes up for me in an interesting posture, because I think about a lot of questions from the perspective of administrative agencies that are positioned in the executive branch. And when you think about the question of legitimacy from that direction, you have to understand that for an agency, a statute almost has like a divine quality. It's the ultimate source of the agency's authority, and all of the agency's authorities hinge on the statute. So there are going to be regulations, there are going to be guidance documents, there are going to be enforcement decisions, but all of those hinge upon what Congress has said through statutory law. And part of the reason that matters is not just the formal fact that the Constitution assigns the legislative power to Congress, but more substantively the claim that Congress has genuine democratic credentials that make that formal power legitimate. But matters are a little bit more complicated than that, because administrative agencies sit within, or at least are closely attached to, the executive branch. And in our system, the executive too has its own partially competing democratic foundations. And so sometimes the question arises, is the agency more fundamentally committed to statutory norms and purposes and to congressional oversight, or more closely aligned with the president, who appoints the membership of the agency, can make various budgetary and review decisions over how the agency proceeds. So there's a weighing of two competing democratic voices. And so the question I want to focus on here is a question about comparative democratic legitimacy between our two elected federal branches. And I think when we think about democratic legitimacy in particular, there are two important things to keep in mind. First is that legitimacy isn't a yes/no question. It's a shades of gray issue. So there's, at least in the world we inhabit, there aren't really any institutions that enjoy complete democratic legitimacy. And at least when it comes to the institutions of the federal government, I would argue that they have some. It's not the truth that there is an institution that totally lacks it. So it's all a question of how much. And beyond that, I don't think legitimacy is a one-dimensional question. When we think about democratic legitimacy, we are concerned first and foremost with majoritarian will, what 50+1% of the population wants. But then there's a second question, which I would describe as pluralism. So when you think about what democracy requires, it requires treating all members of a political community as equals, right? And so one output of that is that if we treat everyone as equals, we respect majority will, because everyone's voice counts for the same. So that's how so equality justifies majority rule. But if we take equality seriously, that also means that we want to make decisions in a way that reflects a number of different perspectives and not just a singular perspective to the exclusion of every other, right? And these two principles can conflict, right? So if you only adopted majority will, but you made no provision for plurality in decision-making structures, then you would undermine the rights of minorities to contest decision, the ability to deliberate and debate, and so you might sacrifice important aspects of democratic equality in the name of instituting majority will. Right? Okay, so if we think about those two dimensions, then I think that gives us some traction to think about the executive branch and the legislative branch and how they relate to each other. So if we look at the majority will dimension, but both Congress and the executive have their own infirmities. Right? So the Senate is not a democratic institution in terms of majority will. Just I think that's pretty straightforward because states with lower populations have equal representation with states with larger populations. And then there's also the significant issue of partisan gerrymandering, which might also undermine numerical equality in a number of ways. And so on this dimension, the executive arguably has some advantages because usually the president wins the majority vote, but not always, right? And not always in a few instances fairly recently. And so the Electoral College creates some complications around that majoritarian mandate. Okay, and then if we look at the second dimension of democratic legitimacy, about pluralism, Congress has decided advantages over the executive because in our system, the executive is unitary. There's only one president who holds the executive power, right? Whereas in Congress, you have a number of officials who are, at least along some fundamental dimensions, equals, have certain equal rights. Now, there are hierarchies that are layered on top of that in terms of, committee assignments and the role of the speaker and important issues like that. But at the fundamental level, the members of Congress within their respective houses hold equal legislative rights. Whereas in the executive, there's one person who is on top. And that conflicts with, or at least is in serious tension with, democratic criterion of plurality. If in a system where one person is making the decisions, it's difficult or maybe even impossible to generate that kind of exchange between perspectives and viewpoints that democratic government would seem to require. Now, that's not to say our executive branch as it exists today is completely hierarchical and unitary, right? So we do have independent commissions who are insulated from removal by the president. There are decision makers in the executive besides the president, like the attorney general, who matter and who, despite the president's ability to remove them, do have at least functionally separate authority within the branch. But note that all of those features of the executive that run against the president's hierarchical control are creatures of Congress. They are generated by statutory law. The reason that the executive has those plural democracy-enhancing features is because Congress wrote them into law. And I think that's a defining feature of the administrative state that developed over the course of the 20th century, is that the executive branch has reconstituted as a surrogate legislative process in a number of different ways. And the reason that's happened, and the kind of the functional motivation for that, is that Congress has taken on a huge amount of social regulatory functions that it can't detail and specify on its own. So authority has to be delegated to the executive, but there are a number of good reasons and social pressures for recreating pluralistic checks within the executive branch. And so just to run through what a few of those checks are. First, Congress usually delegates authority not to the president directly, but to another official within the executive branch, either to a head of one of the departments, or to executive or to agencies, or to independent agencies. And when that happens, it pluralizes authority within the executive branch. It doesn't all come down from the president. It's assigned to different actors across it. We also have commission structures that are governed not by one individual, but by several. We have for-cause removal provisions that prevent the president from removing particular officials at will. And we also have notice and comment rulemaking, which requires agencies to consult the affected public generally before they issue regulations that have the force of law. And it's noteworthy that such regulations issued within the executive branch are called legislative rules. And they're called legislative rules, I would say, not just because they have binding force, but also in part because of the process that they arise through, which is a legislative process that involves policy judgment and that brings multiple points of view to bear. Okay, so that's the big picture shape of the 20th century administrative state, which also, up until Chadha, included the legislative veto, which gave Congress additional ability to influence the way in which the executive branch was structured. But over the past several decades, the court has interfered with Congress's ability to create pluralism in the executive branch. And just to note a few big dimensions of that. First, our Free Enterprise Fund and SAILA Law, the Consumer Financial Protection Bureau, decided this past term, which both place limits on Congress's ability to place removal protections on administrative officials. So to date, those opinions haven't taken a huge bite out of the pluralistic structures of the executive, but the logic of those decisions is to erode all of the subordinate checks within the executive branch that constrain the president's unilateral power. And I would argue that is a serious threat to the democratic legitimacy of the executive branch. The other interesting decision, and I think unfortunate decision this past term that undermines pluralism in the executive, was Little Sisters of the Poor v. Pennsylvania, in which Justice Thomas, writing for the court, seemed to interpret the Administrative Procedure Act to allow agencies to issue binding rules without notice and comment, and then merely solicit comment after the fact, after the rule is already in force. And if indeed that's a ruling that has broader applicability, it will eviscerate the notice and comment rulemaking process and enable agencies to just issue binding regulations and then hear from people later and decide whether or not they want to change their minds. Okay, so there are a number of threats from the courts to Congress's ability to structure the legislative branch in its own image as a pluralistic body. So to conclude quickly, where do we go from here? What kinds of reforms could we make to Congress that would enhance its ability to accrue democratic legitimacy? I'm going to leave aside issues about electoral reform and Senate reform, although I do think those are important and deserve serious attention. Instead, I just want to focus on, first of all, increasing congressional administrative capacity, right? So can we increase Congress's oversight capacity and ability to engage in a rigorous way with the executive branch over time in policing and influencing the way in which discretionary statutory powers are exercised? There are also ways of encouraging pluralism within the executive branch without imposing removal restrictions. So there are ways of assigning offices where you could, for example, create one officer to head an agency who then appoints 3 other officers, and those 3 officers have to have specific qualifications for those positions, and they each have to sign off before the agency acts. That's one example of how you might create pluralism within the branch without intruding on the president's supposed power to remove officials at will. I'll leave it there, but I do have some other thoughts that there are a number of ways in which Congress might fortify both its own democratic legitimacy and that of the executive moving forward. Thank you.
Thanks so much, Blake. Now we'll go to Miriam Seipik.
Thank you all. It's great to be with you, even virtually, though it feels extremely odd to do an academic talk given what's unfolding in DC right now. But we'll try, and I really appreciate the community I see in the chat. So I thought I would approach the question of Congress's legitimacy with a comparative perspective. I'd like to start by describing what I see as the sometimes problematic democratic legitimacy of state legislatures, first by describing a recurring pattern in state legislatures, and then second, explaining why it poses a state constitutional problem. And then third, I'd like to ask, if state legislatures have a legitimacy problem, is there any reason to reach a different conclusion about Congress? Or to the contrary, does Congress have an even greater legitimacy problem? So first things first, as I argue in a new draft paper entitled Counter-Majoritarian Legislatures, state legislatures are often a state's least majoritarian branch. By majoritarian, I'm relying on a relatively minimalist definition here, that the candidate or party with the most votes wins. We could certainly go further down the path of majoritarian definitions and urge that the candidate preferred by the entire polity wins, or that the substance of government policy is preferred by the majority to some reasonable degree, as opposed to, say, only catering to elites. But I'll just use the minimalist definition for now. So majoritarianism in this vision is that the greatest vote-getting candidates and parties win, and my claim is that state legislatures are typically states' least majoritarian branch. This claim might seem sort of jarring at first. After all, if we're using federal government institutions as our reference point, we might think of legislatures as the most majoritarian branch. It's a point that's sometimes made about Congress, or at least about the House, right, the voice of the people and all that, even as this panel reflects, I think, the frailty of that characterization. But in any case, it's a very poor characterization of state legislatures. In states, we have two branches that are typically elected by what I'll call majority vote simpliciter, just a simple statewide referendum, and only one branch, the legislature, that's subject to the distortions and skews that come with winner-take-all elections in single-member districts. That type of selection system opens the door to what political scientists and election law scholars sometimes refer to as a manufactured majority. That is, when a party doesn't get the most votes, but wins anyway, due to the distortions of the election system itself. Patterns of geographic clustering and partisan gerrymandering make this phenomenon more pronounced. And again, in states, it's only the legislature that's susceptible to this possibility. I've looked at some data on this, and it's not a rare occurrence. It's happened in at least one chamber of a state legislature hundreds of times since the 1960s, and in some states, it happens again and again. So my second question is, if state legislatures are commonly not majoritarian, what does that mean for legitimacy at the state level? In my recent work, I have thought of this in terms of constitutionality rather than legitimacy, though I'll connect the two in a moment. In a recent paper with Jessica Bowman-Posen coming out soon in the Michigan Law Review, we argue that state constitutions embody a democracy principle, a shorthand we use for the fact that state constitutions expressly and repeatedly embrace majority rule, popular sovereignty, and political equality. To provide just a taste of the evidence for that, 49 states have an express commitment to rule by the people. All state constitutions confer the right to vote, often with additional requirements like that elections be free and open. State constitutions are far easier to amend than the federal constitution. States directly elect judges and plural executive branches and do so without an electoral college. States apportion both of their chambers based on one person, one vote with no equivalent of the US Senate. Roughly half the states have direct democracy, and so on. State constitutions often enacted these provisions in national waves or cascades in a manner of borrowing and copying. So it is in fact plausible, we think, to speak of a democracy commitment that's shared by 50 states, even as it of course varies in its particulars and has to be analyzed state by state. In light of those commitments, state constitutional interpreters can, and sometimes do, insist on majority rule as a constitutional principle. The recent rulings against extreme partisan gerrymandering in Pennsylvania and North Carolina are an example of that. And so are a number of interesting earlier cases protecting the direct democracy process. And we outline in our paper where else state courts might fruitfully invoke these principles. So to tie these first 2 points together, in many cases, this democracy principle, this commitment to majority rule and related concepts in the states, cuts against state legislatures, or at least weighs against giving them special preference in state constitutional doctrines, which they sometimes get. I'm happy to talk more at some point about the specific interventions I recommend to address that. But in short, non-majoritarian state legislatures equals state constitutional law concern. Now, as I said, this isn't a conclusion about legitimacy per se, but I think it's just a short hop to reframe the critique as saying that under certain conditions, state legislatures lack substantive legal legitimacy, to use Dick Fallon's term. In this way, the state level analysis is in a sense simpler than the analysis we have to confront for Congress. Because of the express and pervasive pro-majoritarian commitments in state constitutions, there is a relatively straightforward critique of state legislatures along constitutional lines. Okay, so finally, let me turn to some questions about what all of this means for Congress. Congress, and especially the Senate, is subject to the same descriptive critique I made of state legislatures, or worse. right? So winner-take-all elections plus single-member districts in the House plus geographic clustering and partisan gerrymandering have led to numerous manufactured majorities. And then, of course, there's the Senate, whose dramatic majoritarian failings are plain. So one way to think about this is that unless there is some countervailing argument, we would view Congress as illegitimate, or more so, for the same reasons and limited to the same conditions that I mentioned for the states. So the question then is, well, are such countervailing arguments available? And here are two big questions I think of as to whether the legitimacy of Congress might vary from that of the states. So the first question is, does legitimacy at the federal level require majoritarianism, at least as a minimum threshold, as I argue that it does in the states? Obviously, there's an important question of how we define legitimacy. If we're speaking just of legal legitimacy, then the clearest reason that Congress might be okay, even if the states aren't, is that the federal constitution is not as committed to majority rule. To be sure, many scholars have nobly identified pro-democracy aspects in the federal constitution, but as Sandy Levinson and others have argued, it's not obvious as a structural, textual, or historical matter. If we sweep in sociological or moral legitimacy, then I think Congress might become harder to defend, at least if it is consistently producing minority rule. It seems to be a commonly shared idea across constitutional law scholarship, political theory, and public discourse to associate majority rule with democracy and democracy with legitimacy. Of course, I think most theorists would add requirements to that, right? Seeking also deliberation and rights protection and minority voice and more. But in the main, it seems that majority rule is a minimum criterion. That is, that there are very few arguments for minority party rule. So then the second question, and this is where I'll conclude, is even if some threshold majoritarianism is required for sociological or moral legitimacy, even if not for legal legitimacy, then the question is, well, are we getting it? Or something else acceptably democratic through some sort of system effect or operational effect? That is, even if the seat share in Congress is itself not majoritarian, might there be other ways that majoritarianism is essentially reconstructed through either ample compromise or cross-party voting or other means of sort of reaching across the aisle to produce shared outcomes? Or maybe some of the non-legislation activities that Josh talked about, like oversight and overspeech, could function in some sort of quasi-majoritarian role. Perhaps most interestingly to me, and something that Jessica and I considered in our paper, is that maybe the majoritarian orientation of state constitutions could partly offset minoritarian tendencies in the federal constitution for a sort of overall federal pro-democracy effect. So for example, the availability of direct democracy in these states could give force to social movements and cascades that ultimately hold sway over the federal government. Now, admittedly, since I've just said that state legislatures are often minoritarian, that vision of states counterbalancing the feds is not exactly going smoothly. But I think it's an important possibility and relationship to consider. And in particular, I think it's worth thinking about the fact that reforming the states might end up being an important way to reform and add to the legitimacy of Congress. And I will end it there. Thank you all.
Thank you, Marian. And finally, Fernanda Tolson.
Thank you. I'm so happy to be here with everyone, even if it's virtually. Quick caveat, you may see a little face appear to my right. There's nothing I can do about that. She does not respect that mommy has a presentation. She just does it. So just sorry. So I approach this question of congressional legitimacy in a similar fashion as some of the other presenters in terms of thinking about what the baseline for legitimacy is or ought to be. And in particular, I ask myself, well, what does it mean for an institution to be legitimate within the context of a constitution that is imbued with elements that are in tension with how we usually think about democratic legitimacy or the idea of having the support of a majority of the people? So I think because of the framing, this question of legitimacy often perplexes me. For example, the Supreme Court told us in Rucho versus Common Cause that some level of partisan gerrymandering in drawing congressional districts is okay, even if it distorts the will of the people. And in either case, they're not going to police it anyway, right? And of course, each state gets 2 senators, as Pete points out, and this is true regardless if the state has 4 million people or 40 million people. And some people would say that that's illegitimate. And finally, keep in mind that our system is such that had both houses of Congress been in one party hands, then we could have ended up with a very different president today, even though the outcome of these proceedings remain to be seen if they'll finish them, contrary to the wishes of the people. But our system technically permits that. So what do we mean by legitimate here? All of this seems pretty illegitimate to me, but it is our system to some extent. But one thing I can conclude from all of this is that we, the American people, have failed to properly constitutionalize how we see ourselves as a participatory democracy, even if it is the standard by which we judge the legitimacy of our government. So for me, the next question is whether legitimacy requires that we constitutionalize our expectations for how our government should operate, or are our norms and practices enough to sustain us? I think the answer to that question must be sort of, maybe, possibly, okay, maybe it depends, right? It could be a very fluid thing. But the reason I think this is hard is because we've been guided by democratic principles for over 2 centuries. And although there have been fits and starts and backsliding, there has always been both constitutional and extra constitutional progress on this front, even if the progress does not perfectly align with our expectations. We often want more than our politics can give us at the time. Nonetheless, it turns out that our democratic expectations are important, particularly when our Constitution uses words like Republican government and enshrines protections for the right to vote. The history bears this out. So the baseline of legitimacy has shifted over the course of 200+ year history, which functionally means that governmental legitimacy is more so a matter of dates and practices and perspectives rather than some objective notion of what counts as legitimate government. For example, if representatives up for election in 2020 were elected from states that mirrored the political landscape of the 13 states in 1789, then I think everyone would agree that it would hardly be a recipe for legitimate government by today's standards. The disenfranchisement of African Americans, women, propertyless white men would deprive these states and their representatives on the national stage of any claim to legitimacy, given that events have transpired since that era, including the expansion of the electorates in the states as early as the 1790s, beyond property white men, as well as constitutional amendments that were enacted to enfranchise various groups over the course of 2 centuries. While these governments might have been legitimate by 1789 standards, we the people have redefined the majoritarianism underlying the Republican guarantee to embrace more democratic ideals, and in the process reset the baseline for what constitutes legitimate government. Having an electorate that consists almost entirely of white men would not only violate the constitutional text, it is also not within our collective understanding of a legitimate electorate independent of that constitutional text. But there's a clear downside to filling in the blanks surrounding democratic legitimacy with our collective expectations and norms. The failure to constitutionalize all of our expectations on this front, particularly when it is apparent that there's a disconnect between the people's views of how government should work and the minimum that the Constitution requires, is that it subjects us to backsliding. For example, the Constitution might prohibit discrimination on the basis of race, but does it prohibit race-neutral practices that have the effect of discriminating on the basis of race? 50 years ago, I would have comfortably answered the question in the negative. I would point to the 15th Amendment and the VRA as proof of this fact. Now I would have to consider the lineup of the Supreme Court, the ages of the justices, where the law professoriate is. Gosh, will the Department of Justice enforce the Voting Rights Act at all? I would query whether Section 2 of the Voting Rights Act is constitutional, and I would think about a host of other factors before I attempt to answer this question. Our current controversy only reinforces this point. Our politics are such where political elites are questioning the presidential election. We see this playing out in Congress today, but this is functionally because Black and Brown people have voted in a way that they don't like. Is this any different from viewing the desirable electorate as one in which it is predominantly white, like the electorate of 1789? And while there are a number of reasons why we find ourselves in this situation, part of the reason is that some states have been successful in passing measures that would keep the electorate mostly white and affluent, because while we constitutionalize a prohibition on racial discrimination in voting, we have not explicitly constitutionalized our expectation that the right to vote should be available to all those legally entitled to vote without artificial barriers that make exercising that right illusory. We can play with the language of the Constitution with respect to our expectations in terms of trying to make them permanent. I mean, I do it all the time in my writing, arguing that the implicit right to vote in the document should be read broadly, trying to flesh out all of the assumptions about voting that underlie the text. The court has done it as well, right? See Harper versus Virginia State Board of Elections, where the court infers a right to vote from the 14th Amendment. But when we don't make our expectations, our assumptions, when we don't make what is implicit actually permanent, then we can lose ground like we have in the 7 years since the Supreme Court invalidated a portion of the Voting Rights Act in Shelby County versus Holder. As it stands, the Constitution is a framework. The details are in the politics and the social movements and the wars, the bloodshed and the sacrifices, all the things that we the people have given in order to create the democratic norms that are now under threat. But as long as this is a situation in where the details are contingent, we will always be at risk because the only standard of legitimacy that is permanent is the one that is constitutionalized. Why? Because the government can be illegitimate according to our norms, but still meet the constitutional minimum, insulating that government and political elites from effective pushback when they violate our norms. To make this point concrete, consider that there have been a number of resets over the course of our history that inform whether our government has democratic legitimacy. The most obvious reset was Reconstruction. The lesson from Reconstruction is really about how that era changed what we considered legitimate government and how that expectation didn't last because our expectations were not properly constitutionalized. Reconstruction offered some of the most diverse governing bodies in our country's history, but it didn't last. In the 1890s, the former Confederate states adopted discriminatory state constitutions that disenfranchised most of the African-American population in the South. But the constitutions were race neutral, so technically the 15th Amendment, as then interpreted, did not reach these provisions. Mississippi's 1890 Constitution is one example of this. Mississippi imposed an onerous residency rule, a literacy test, a poll tax, and it had the effect of cutting African-American turnout from 30% in the 1888 presidential race to virtually nothing thereafter. In addition, the Republicans lost control of Congress in 1874, and control of the chamber alternated between the parties for the rest of the century, making it difficult to impose the penalty of reduced representation envisioned by Section 2 of the 14th Amendment that would address the disenfranchisement triggered by the new constitutions enacted across the South. It was not until the 1960s that there was significant federal intervention to outlaw some of these practices. The Civil Rights era, in effect, represented another reset. Recalibrated our expectations about what democratic government should look like through constitutional amendments, the Civil Rights Act, the Voting Rights Act, Supreme Court cases like the aforementioned Harper, as well as Reynolds versus Sims and other cases. Yet we have not updated our constitutional text in recent decades to respond to concerted efforts to prevent voting from expanding beyond the bare minimum that the Constitution requires. Supreme Court majorities have shifted. Statutes, as we know, can be invalidated. Text falls short. Yet our Constitution has remained static. The ebbs and flows of our democracy make it clear that from the time of the founding, the composition of the electorate has largely expanded, even as there have been new and varied restrictions targeting certain groups at various points throughout our history. Reconstruction saw the largest expansion, incorporating African-American men into the composition of We the Voters. The 19th, 23rd, 24th, and 26th Amendments likewise represented our commitment to a broader electorate. Each expansion represents a reset for our baseline of democratic legitimacy. The failure to constitutionalize the changes in our expectations that accompany these amendments, which alone were not enough to give life to the democracy that we envision, makes it difficult to hold on to the progress. Keep in mind that the increased gerrymandering, the poll closes, the restrictive voter ID laws, all the efforts to disenfranchise minority voters since 2013 are happening within a constitutional framework that at one time promoted the enlargement of the electorate, but it was clearly not enough for this current moment. Hence the backsliding, hence the claims of illegitimacy. Unless we find some way to entrench democracy, as Michael Klarman persuasively argued in his recent Harvard Law Review foreword, then we will always find ourselves in a perpetual and never-ending crisis of democratic legitimacy. Thank you.
Thank you so much, Fernanda. Okay, so at this point, I want to turn to the audience questions. So if you could just ask questions in the chat, I will relay them to the panel. And the first question I saw earlier up in the chat here, I guess this is a question to the entire panel. So for Miriam, you referenced that it's sort of hard to give an academic talk given the events that are happening at the moment, and Katie Kovacs asks how those events lead you to rethink, or how you sort of reconcile what we see happening, in Congress today with the way that you have approached this question coming into that, and just to sort of editorialize, like for instance, Josh, you were sort of hailing congressional divisiveness in part in your discussion, and do events like we see today make you call that into question, or no, or yeah. So just any thoughts from any of you in terms of how we should think about congressional legitimacy in light of sort of what we see going on right now?
I guess I'll start since Ryan called me out on that. So I think I think we want to separate out two things that we're seeing today, right? One is the challenge by some Republicans in Congress to the election outcomes, and then the other is the physical violence, the storming of the halls of Congress, and they're not wholly disconnected from each other, of course, but one could certainly have either of them without the other, right? And I think to my mind, one of the interesting things about sort of late Trumpism is the way that it has really split the Republican Party, right? So, I mean, to me, one of the interesting things about what was going on today before the violence sort of started in the halls of Congress was just how few Republicans were actually sort of involved in this. It seemed like at the end of the day, it would be fewer than 15 Republicans in the Senate, probably fewer than 100 in the House. To my mind, that actually, although it is a stain on each and every one of them, is not actually sort of writ large cause for significant concern. On the other hand, and I'm turning because I can hear sirens right now. On the other hand, the violence itself is significantly more cause for concern. Right? So I don't think that divisiveness, sort of procedural divisiveness, is at the point where I would regard it as a serious threat. I think violence, on the other hand, is.
Okay. Any others? For Nita, I suppose today's events mostly just reinforce the sentiments that you were just expressing. Is that right?
So to piggyback on Josh's point, it does make me wonder though, to what extent does procedural divisiveness feed into the public's perception about the legitimacy of government, right? To what extent are the crowds that are storming the Capitol responding to the fact that there are Republicans in Congress who are willing to use procedures to challenge this presidential vote? And so I take, and Josh, I apologize, I came in like the middle of your presentation, I think. I take your point to be that some procedural divisiveness is healthy, right? But I wonder if our polarization is such where you can take something that's normally a healthy thing and it turns into a very terrible thing that sort of feeds into the dysfunction that has been sort of laying right beneath the surface for so long. And so I do think it's important to keep perspective. I don't think that, I do think, for example, you can have gridlock in Congress that actually contributes meaningfully to policy change, right? There are things that have become demonized in this moment that under normal circumstances would be a healthy sign that we are in a democracy. But I just think that our polarization and the president's rhetoric and all the things going on have really corrupted those things that we normally look at as good things in certain circumstances and make them very negative.
Also, just to chime in on that quickly, I think one thing that we're seeing today is a particularly vivid and extreme version of the dangers of the sort of plebiscitary democracy that sometimes operates through the executive branch. So what we've seen, not just in the Trump administration, but over time, is that more and more power has been concentrated in the presidency and in the executive branch as a unilateral actor who makes big promises that people expect them to deliver on, and who tries to forge a direct connection with a mass social movement. And that can be very inspiring and uplifting if you're on the right side of that, and it can be the opposite if the social movement is moving against you. And that sort of politics, it lacks pluralism, it lacks procedural control, and it can spill into violence as it has today. So that's, but what we've seen in the Trump administration, what we've seen over the development of the unitary executive theory is the erosion of the sorts of structures and controls on the executive that I think honestly have made this moment possible. And so I do think there's a longer story here besides Trump about how our constitutional order has evolved that we need to seriously reckon with.
Great, thanks. Let's see, go to the chat here. Question from Nicholas Almendares for Josh. Performative is contrasted with honest, and that seems to be a precondition for oversight to be informative. What can we do to prove that?
Well, so I guess I'm not quite sure. So I think sometimes in popular discourse, performative is contrasted with honest. I don't think that's correct, right? I think that the truth needs to be performed just as much as lies do. So I think the question really is, I think there's sort of two orthogonal questions almost, right? One is what is being communicated, right? Is it true or false? Is it good or bad? And then there's a question about the efficacy with which it's being communicated, right? Is this performance a successful one or a failure? And so I think it helps understand that those are two separate questions, and that to talk about sort of the performance of it is not to say anything about the truth value of it, and to talk about and indeed it would be a mistake to suggest that there are any sort of statements that are being made to an audience that are not being performed with greater or lesser sort of levels of success. So I think part of the key here, right, is trying to adjust people's expectations. And that's why I find the legitimacy framing so interesting, right? Because discussions about legitimacy take on this self-referential character, right? If we're talking about sociological legitimacy, things are legitimate to the extent that we believe they are. And we believe they are to the extent that they comport with ideas we have about legitimacy. And those ideas about legitimacy are constructed through our discussions about legitimacy. So so there's a sense in which, right, the sort of role of people who shape education, who shape public discourse, who shape sort of discussions of these things is actually fairly central here.
Great. So again, feel free to jump into the chat with any questions. For now, I'll ask a few questions of the panelists in the meantime. So for Nita, you, I think, rightly observed the sort of increasing gulf between the sort of written constitution in terms of its sort of commitment to democracy and our sort of societal understanding, or even our maybe sort of informal legal conventions, even in terms of a stronger commitment to some sort of majoritarian rule. And you say that the sort of real sort of danger and or failure to formalize those informal commitments is this threat to democratic backslide. And I guess when I hear that, so I think the observation of the gulf is surely correct. But I guess I'm wondering, sort of, how do you see? I guess how would you see this playing out? What would the sort of backstop look like? And I guess this relates to sort of what's the problem? Because I guess they're sort of like in terms of like what would be the mechanism is the idea that by amending the Constitution to contain express commitments to sort of a more robust vision of democracy, is that we are empowering courts to step in and intervene when our elected officials fail to live up to democratic commitments, like we might worry that at least some members of Congress are today, or is it something else? Or are we imagining more sort of formal structures that we're not even relying upon judicial intervention? I'm just curious how we would see this playing out in the event that we were to amend the formal Constitution to bring it closer into alignment with our commitments.
I actually don't know. And to some extent, I deliberately avoided that question. It's a fair question, right? Because one of the struggles I had in thinking of and working through my thoughts is that there's always going to be some space, right, between our expectations and what the Constitution says. But Miriam's presentation actually got me to thinking about state constitutions, which I've thought about some, but when she makes the point about how easy they are to amend, and also state constitutions do have a firmer commitment to democracy than the U.S. Constitution. It's explicit. Even if we could start there, right? There are, there's a right to vote amendment pending in Congress now. That would bring us closer to the vision that I imagine. So it's not that, there aren't things that we can do. We can certainly be better about this, but I think my concern is a larger one, right? Even after we do that, if there's still space between the new legal regime we've created through constitutional amendment and our expectations, do we have a procedure in place to address that space? And I don't think Article 5 is really a good way of doing that. It makes the Constitution so hard to amend that even if we overcome the hump at point A, when we get to point B, things remain static because it's so difficult to build a political coalition necessary to enact change and respond to the fact that we changed from where we are at point A. So I think my concern is dual, right? Like, yes, let's update the Constitution to reflect where we are as a polity, but also we need to think about how hard it is to change the Constitution, because that makes it even more difficult to reflect who we are as a democracy. So I don't know if there's a good answer to that, because Article 5 is what it is.
Yeah, because that was one question I had for you. I was wondering, because on the one hand, like, right, to the extent to which the more difficult it is to amend the Constitution, on the one hand, it's harder to keep up to date, but on the other hand, of course, the degree to which it will prevent backsliding of a particular once something is increases. So I was curious how you thought about that in terms of like the extent to which we thought it was desirable to make it difficult to amend. Because I guess on the one hand, right, because state constitutions are obviously much easier to amend, but on the other hand, it might be amended in ways that might normalize the sort of backsliding that you're concerned with.
Right. This is true. And that's part of the reason why I am, sort of a loss about a good answer to that question, especially since, Miriam also pointed out that state legislatures are, not necessarily majoritarian, which is state legislatures are a creature of state constitutions, right? So you could have a written document that's more democratic, more majoritarian, and still end up with minoritarian institutions, right? So, maybe it's best to think about this incrementally, right? There are things that we can do in order to respond to the moment, right? We can update the Voting Rights Act. We can amend the Constitution to have a right to vote amendment and take it a step at a time. But I don't think it gets us away from that basic problem that it's difficult to amend our Constitution. And as a result of that, it'll always be hard to respond to the moment.
I was just going to jump in with one thought on that. It seems to me one thing to add to this discussion is just kind of the idea that law is never enough. I think this sort of builds on what Pranita is saying. You can have laws that are just absolutely ignored if you don't have a sort of legal and what I've called constitutional community willing to take them up and make them meaningful. You can have the opposite, which is, you can have a country with no constitution. I'm living abroad right now, so it's in my mind, that actually has a fair amount of respect for democracy and treats it as a social norm. But you really can't have a meaningful legal or constitutional commitment to democracy devoid of a polity, a social community, a legal community that's willing to take that up and make it meaningful. And so, so maybe one way to think about that relationship is that constitutional development and legal change and even new sort of super statutes can frame that social conversation and can incentivize legal actors to renew their commitments or make better upon them. But I think you have to think of those two components in relationship to one another.
Because that's an interesting question in terms of, because that's another question that occurred to me when I was listening to both of you in terms of whether sort of constitutionalization is the right route at all, right? And if you think about the present moment, right, and we so Blake and others mentioned sort of hardwired anti-democratic features of our Constitution on the one hand, right, the sort of most rule-like portions of the Constitution that seem relevant to democracy are sort of the more sort of most like plainly anti-democratic. And on the other hand, in terms of the pro-democracy, we have sort of vaguer provisions like the Equal Protection Clause, things like that have been interpreted creatively, and that seems to be to the extent to have a sort of pro-democracy sentiment expressed in the Constitution. Say abolition of slavery, things like this. We have sort of judges sort of giving content to these sort of vaguer phrases. And so I guess I wonder if that sort of contrast makes us question whether sort of in a way constitutions are more of a problem than an aid in this space.
Maybe, right? One thing that strikes me is that to what extent did our founders kind of leave us in a pickle on purpose? Right? They use Republican guarantee without any clear sense of what that word means. We think about it as, 50% plus one, but it also embodies all of these other ideals and norms at the founding that they just assume that people would know. Right. And so they, even in 1868, with the ratification of the 14th Amendment, equal protection of the laws, due process, like these are, pretty open-ended terms that leave room for interpretation and leave room for to figure it out. So to some extent, a written constitution is not necessarily meant to solve all of our problems. And I think it comes back to Miriam's point about the importance of social movements and customs and norms and filling in the details and the blanks. But to come back to an earlier point you made, Ryan, sometimes that means that some of the backsliding becomes formalized. It can become informally formalized in our norms. So, having a written constitution will not necessarily insulate us from all of the things that I complained about in my talk.
I mean, to some extent, we've sort of recreated the David Strauss irrelevance of constitutional amendments, except not just for amendments, but for everything, right? Irrelevance of written constitution, right? Because either are sort of sufficiently, like you have the specific provisions, but for the most part, right, those only get constitutionalized after they've already largely come about in practice. Or you have the open-ended ones that maybe get constitutionalized when there's a sort of insufficiently theorized agreement about what they mean, and then what they mean turns out to be sort of however they get sort of taken up by social movements at later periods, right? So they can either be read down to almost nullities, as happens during redemption, or they can then be sort of seized upon anew, as happens during the civil rights movement, where the same sort of equal protection of the laws comes to mean radically different things.
Exactly, like the 1875 Civil Rights Act, the 1964 one, right? Like one's unconstitutional, but the other one isn't. Really?
I have a question from Jack Bierman. He asks, what do you make of the current conservative answer to the complaints about infringement on quote unquote democracy? Infringements on democracy, that we aren't a democracy, we are a republic. Is Congress's legitimacy measured by internal norms, or is it following the Constitution, or external norms? Is it legitimate in some philosophical sense? So what do we make of it? Are we impressed by the "it's a republic, not a democracy" objection, or response, or no? And if not, why?
That conversation has always been it's a frustrating one, because if we're talking in good faith about this question, then there are a number of respects in which we are a republic and not a democracy, right? I mean, we're not governed by straight majority rule. We have a system that emphasizes the distribution of power amongst a number of different actors in order to restrain its exercise. And those are fundamentally Republican principles, and they're only arguably democratic ones, right? So I think if we're talking about from the perspective of like a political theory discussion, then there is an argument that Republican ideals compete with democratic ideals within our Constitution. But my worry about that argument, the way it's been brought to bear, like by Mike Lee, for example, is that it tends to work as an argument for disempowering citizens, right? As you could even call it an esoteric argument towards tyranny, right? And so it's when Republican ideals are used as a cudgel against citizens' right to shape their government that I think we have to push back on the level of rhetoric, even if there's real value to Republican ideals, and there are genuine arguments that a true conception of democracy has to bake in Republican checks in order to work properly. And that's a conversation that's worth having.
I do think the term republicanism is broad enough to encompass a number of different governments, including democracy, and that you have to take into consideration that we have trended towards democratic ideals over centuries. And so to the extent that we want to continue to use that label, then that requires certain things. And I often find that people use the "we're a republic, not a democracy" argument to excuse bad behavior, which is, I guess, a more crass way of saying what we said very eloquently.
I thought I was already being crass, but
I might take a slightly different take than either of you and just say that I think in the context of any modern state, the two terms are synonymous. That is to say, while one can, in theory, describe sort of an ideal type of a democracy and an ideal type of a republic, and they may be different, in fact, one is not going to find that those differences sort of cash out meaningfully in practice in the context of sort of large modern states. That is to say, you're not going to find anything that would fit exactly with a classical conception of a democracy, nor anything that would fit within a classical conception of a republic. We use the two words to describe the same kinds of political arrangements, and therefore, the same conclusion both of you came to, right? The people actually making that claim are up to something else, right? They're not just being pedantic for pedantry's sake, but they're actually using it to cover something.
I don't know if I necessarily disagree with that, actually. I think part of the reason I draw a distinction is because of this understanding that republicanism developed in the context of monarchy, really, right? They were trying to sort of make sense of Republican principles in the context of having a king. So, I think historically they were different, but I think now when people use the terms, they probably do think of them as being synonymous.
I mean, I would describe the UK as democratic. I would describe Spain as democratic. Right? They both have monarchies.
Yeah, but now the monarchies don't really do anything except, spend a lot of money and end up in the tabloids. But 300 years ago, it was a different story.
It's worth noting here that there's a really lively conversation in political theory of a kind of left-wing republicanism that recovers the idea that in its more classical form, republicanism was about protecting and balancing the interests of the many against the interests of the rich few, and that our country has slipped into an oligarchic arrangement where the many, like the 99%, do not have sufficient resource or political power, and we have fallen away from republicanism in the sense that the rich simply have taken over control of the government in large part. And so I wouldn't want to reject Republican language because I think it can shed light on the way in which formal political power overlaps with material social power, and that's an important point that stretches all the way back to Aristotle and to Machiavelli. So that's an important part of the question about republicanism today.
I think I took Josh's point to mean more so in our political discourse as opposed to theoretically. Because I think you're right that, theoretically this distinction does have implications, but I think in our political discourse, people use them interchangeably when it's convenient until it's not.
Right. Well, go ahead.
But just a quick response to Blake's point, which is I'm pretty sure John McCormack uses the phrase democracy in his book on Machiavelli to describe precisely the phenomenon you're describing as unity, separating out republicanism from democracy. So I think there's still a sort of conflation there, even in the theoretical literature.
Yeah, and I was just going to say that I think that these discussions in the theoretical literature are really interesting and can be fruitful. But I took part of Jack's question to be sort of what type of legitimacy do we mean to invoke when we talk about whether Congress is legitimate? Mm-hmm. To the extent that we're asking that, it's really about and what is acceptable to the people. And I don't think that there's that a version of republicanism that means sort of rule by a minority party elites, if that's what it's being invoked to defend, is not acceptable. Why it was broadly not acceptable across multiple sort of different sort of things of thinking and background. So if it means something else, then all of these sort of points and different conceptions, could add to the richness of discussion about legitimacy. But I think, to the extent that it's being a stand-in for this, what I just described, then I don't think that it could be legitimate in the sense of sociological legitimacy.
Okay. So Joshua Braver asks, I'm wondering if we live in an age of a very impoverished imagination of constitutional reform. Each age has had to deal with a way to overcome the veto gates in the Constitution. Jackson invents the political party. Reconstructions give a whole new heft to the judiciary and the national government. The New Deal creates the administrative state, building a flowering of progressive constitutional thought. Today, all we have is packed the court and DC state. So is the problem a lack of guts in our constitutional imagination? And does it speak to a legal academy that is too wedded to professional norms, standard academic knowledge, rather than dedicated to thinking as creatively / wildly as our progressive forefathers and mothers did? So are we just too timid? Is that our problem?
No, there's a group of law professors
meant to be raised by this panel. So
no, there's a group of law professors who are meeting and trying to figure out how to reform the Constitution now. So I wouldn't say that it's about us being timid. I will say, and in fact, Sandy Levinson has been pushing for a new constitutional convention for as long as I can remember. So I don't think it's a issue of being timid, right? I do think that these ideas are out there. I don't know if we have been as organized about it. To me, the efforts now, the discussions now seem more organized now than they had in the past, right? It seems like the law professor is trying to take advantage of the moment, and it's not just law professors. It's also people who work in public interest and are affiliated with various organizations like that are trying to take constitutional reform more seriously in a way that I haven't seen, at least in my career.
This does make me wonder what Josh Braver has in mind.
But I think, Fernanda, I think your point is totally well taken. I think that you do see, because it is interesting to see, on the one hand, you have people like Sandy out there who sort of, have been pushing, Mark Tushnet, people pushing sort of more radical lines in times when that was getting very little sort of practical traction. And now we're in a moment where these sorts of proposals seem to be taken much more seriously. I think both in the academy, but also just in the political environment more broadly. And it's an interesting question. On the one hand, it might just be, I guess this goes to this more fundamental question of like, what is the role of the academy in relation to these sort of, in these sort of practical or political developments? Mm-hmm. Does the academy have a potential leadership role, or is it a matter of sort of articulating thoughts, and then when the practical conditions arise, we're there already?
Yeah. And I will say it's not just the left either. I know that people are, sort of worried about a particular vision of the Constitution. The National Constitution Center is groups to think about the Constitution from both a conservative and a more progressive perspective. So this isn't just a left-leaning issue or a left-leaning effort. This is a sort of a across the political spectrum effort to reform the Constitution in a way that I think could be fruitful.
Great. Wait for some other questions from the chat. Until then, I guess both Josh, going back to your the sort of promotion of divisiveness on the one hand, and then Fernanda, you mentioned the sort of extreme conditions of polarization and the challenges those are presenting. I was curious, sort of all of you, sort of course, another sort of event that sort of might inform when thinking about these issues are the Georgia special elections last night, or concluded last night, seemingly changing control of the Senate. And one thing that I thought was very striking in terms of the rhetoric in the aftermath today was from many of the relevant individuals, calls for bipartisanship, right? Calls for sort of reaching across the aisle, reaching broad-based consensus, bringing an end to divisiveness, to this sort of partisan clash. And I guess I'm curious what you all make of those reactions. I guess both like descriptively, like what significance do you think those have, but also in terms of as we think about congressional legitimacy and legitimacy of governance more generally.
Well, I guess I'll say I think that regardless of what the people making those claims sort of have in mind in doing so, those claims are necessary sort of preconditions to whatever comes next, right? So we've got a 51-50 Senate, presumably, and we've got at least several members on the Democratic side who are at this moment not prepared to nuke the legislative filibuster. That means at the very least, the only thing leadership can do talk about bipartisanship and either try to get some Republicans to come over on various issues or demonstrate to the Mansions and the Cinemas and others in the party that, hey, they're not going to work with us on anything, so we have to nuke the legislative filibuster, right? Those are basically the two ways this could go down. So, but either way, you've got to be talking about bipartisanship right now, whether sincerely or not.
So I think on one level, divisiveness is just part and parcel of democracy, right? I mean, you're not going to have a rule by majorities with any kind of deliberation that doesn't involve divisiveness, and it should be, and it should involve contention. And if it doesn't involve contention, it's probably because some people are being made to keep their mouth shut, and that's not democracy. Now, at the same time, I think it's a problem that we have lost there's a danger that we've lost any consensus that some things are out of bounds, that we're not gonna mess around with the electoral process. And so in some sense, I found it incredibly democratically reassuring just to see state officials competently and steadily counting ballots. So you need to have that infrastructure in place and to keep it outside of the bounds of contestation in order for that contestation to remain and stay in place. And so I think that's a constitutional and a legal project that we need to undertake now, is to strengthen that infrastructure before the erosion we're seeing today becomes irreparable.
Brian, you're muted.
I think you're muted.
Thank you. Another question. So another point that's come up at a couple points in our discussion, both Miriam and Fernita, you sort of mentioned the relative degree of commitments to democracy and majoritarianism in both state versus the federal constitution, and sort of course hovering around this conversation is this sense of a question of like, okay, what sense of legitimacy interests us when we ask, is Congress legitimate? And we might be interested in numerous senses, right? We might be interested, talked about sociological legitimacy, just whether the public in fact regards Congress as legitimate versus normative legitimacy, right? Whether there is a sort of reason to regard Congress as legitimate. And I wonder, I guess the broader question is, how should we think about the relationship between, like Miriam, you started off by talking about the sort of the legality of certain arrangements or constitutionality. And then you said, it's a sort of short step from observing that there are constitutional questions that could be raised about, let's say, state legislatures, to questions about, moral or normative legitimacy. And I guess I wonder sort of, how do you all think about the relationship between, on the one hand, sort of like legality or constitutionality on the one hand, sort of as a matter of positive law, and legitimacy, both, I guess, in terms of as a matter of sociological legitimacy. Do we think that questions of legality are sort of meaningfully informing people's assessments today in terms of the legitimacy of, the legislature or other governmental institutions? Or do we think the sort of invocation of like legal arguments that we see, let's say, surrounding the election, do those seem to be doing any work, or do we think they're more sort of pretextual or epiphenomenal, where really doing the work is more just an underlying normative assessment? And so I wonder, on the one hand, the sort of relationship between legality and sociological legitimacy, that's sort of one question. And then another, of course, is the relationship between legality and normative legitimacy.
Well, there's lots to unpack there, and I don't profess expertise in sort of the depths of political philosophy regarding the relationship between all of the different strands of legitimacy. But I guess I think somewhat optimistically, and so I guess I would start by saying that the sort of legal legitimacy and other types of legitimacy are distinct but potentially reinforcing, and that one area in which we see that is the use of legal claims to make normative claims, right? And it's not always done, but it's a powerful register. I think particularly in the U.S. actually, I feel like I have a lot of I get a lot of questions from family members and stuff that really want to know, well, was this legal? As if its legality was sort of proof of whether it's right or wrong. Those things are in fact distinct, but being able to sort of argue in the public square that, something such and such was inconsistent with the law or inconsistent with the rule of law, even more powerfully, I think does add important weight to certain types of arguments. Obviously, that's not to say, from a sort of objective standpoint that everything that's legal is normatively desirable, or vice versa. There's a gap and sometimes an abyss between the two, but I think they can be used in mutually enforcing ways. And that gets back to, I think, Bernita's and my previous discussion about the value of actually constitutionalizing certain things that you want people to care about, right? Because then it allows a different set of actors to speak in a different register, with authority, in and out of courts about sort of, what our true commitments as a nation are. And those become stronger actually in the federal realm, where we have this sort of longstanding, often criticized, but this longstanding devotion to constitutionalism, and maybe less powerful actually at the state level, where, the sort of amendomania, as some people refer to it, may have devalued to some extent the worth of constitutional argument. So those are some thoughts on that.
Yeah, I think there's an important distinction in Weber's theory of legitimacy between charismatic legitimacy versus legal rational legitimacy. So on the one hand, and you can think of the president as representing the latter, and Congress as the representing rational legal legitimacy. And so there are different ways of in which people identify with and assess political authority. And so when people are attached to the law, it provides them with a general rule or principle that they can argue with one another about, right? So if you think about the fact that Congress has enacted the Civil Rights Act of 1964, that represents a national democratic commitment to non-discrimination on the basis of a number of different statuses and characteristics. And so people, as Miriam was saying, people can kind of deploy that law in argument as a reason to act a certain kind of way or not to act a different kind of way. That's a very different mode of engaging with the world than identifying with a particular powerful figure who you feel who you like what they're saying, you think their decisions are the right ones, because it's harder to reason with others around a norm when you're just talking about isolated actions. So one example, and I'm borrowing here from my colleague Shana Schifrin on this, it would be the Obama administration's deferred action policy, which I think was a very laudable and important policy. But I think, consider, for example, how different it would have been if that was a statutory decision. The normative weight that attaches to a statute that Congress enacts, in part because of the difficulty of doing so and the plurality of people involved and the perspectives, is just much greater than it is if an official who's subject to the president makes a decision based on the president's political priorities, because it's unilateral. It just represents the president's constituency, not people who are opposed to the president. So it doesn't have the same kind of currency in argument and in generating community that statutes do. And so I think we should at a minimum tease out those two different ways in which people think about the legitimacy of authority, either in terms of norms or in terms of particular decisions they like.
Can I just piggyback really quickly to make a point that I think ties into what Blake has raised? One of the things that comes to mind is, and why this distinction might be important, is because I was thinking about the fact that we had an election. The elections were carried out pursuant to state law. The results were certified pursuant to state law. Yet the people storming the Capitol today will probably say that they're exercising their right to alter or abolish government, right? And so how do you reconcile that? How do you reconcile a process that was carried out in accordance with law and the people exercising what they perceive to be a natural right in response to what they view as illegality, right? And so, it's amazing to me that after 230 plus years, we still haven't managed to sort of reconcile the role of law in constraining the behavior of our citizens.
Yeah, and I think that ties back into Joshua's provocative question about the ambivalent role of legal academics in with these kinds of questions, because for the most part, we reason from an existing rule, and that's how we construct arguments and criticisms. And but there's always the question, the power that's behind the rule, and the power of the people to change the rules, and that's a question that legal academics can engage with, but it's one where it's an open question whether we have any special tools to influence that discussion if we're no longer reasoning in terms of the law, but in terms of some extra legal sense of wrongness and rightness. Is that a question that legal academics and lawyers should be answering, or is it one that everyone in society is equally equipped to answer?
Okay, so I'm being told we only have a few minutes left. Do any of you have any sort of closing remarks you want to make before we wrap up? No, everyone okay? Mary? Okay,
I was just going to say thank you for organizing, and thanks to everyone for joining us today. It's great.
Thanks so much to all of you. It's really fantastic. And thank you everyone for tuning in, for your great questions. Really appreciate it. And hope to see you all in person next time. Thanks.
Thanks, everyone.
Take care.
Everyone.
Take care.